Hi, welcome to today's edition of our Casework Conversations podcast at the Housing Ombudsman Service. I'm Sana, an apprentice within the Sector Learning and Development team, and I'm joined by Charlotte Harriott, who's one of our investigators within the Dispute Resolution team at the Housing Ombudsman Service. Hi, Charlotte. It's lovely to have you on our podcast today. So that our listeners can get to know you a bit better, could you introduce yourself and tell us about your role at the Housing Ombudsman Service?
Hi, Sana. Yeah, thank you for having me. I'm Charlotte, and I've been an investigator at the Housing Ombudsman since January 2023. I investigate complaints brought to us by residents who've completed the landlord's complaint process and remain unhappy with the outcome of the investigation into the complaint. So we just ask for evidence from both parties in order to reach an impartial decision. We look to see if the landlord has acted fairly and reasonably and whether it's acted in line with its policies and procedures.
That's brilliant. So thanks so much again for joining me. Really looking forward to today's podcast. So we're here to discuss a case that you investigated and determined in May 2025. It was about a new build shared ownership property, wasn't it?
Yes, that's
Yeah,
right.
brilliant. Could you tell us a bit about the complaint and the background of the case?
Yeah, so this complaint was about the landlord's response to the residents' reports regarding an absence of a footpath from his property. And we also investigated the complaint handling. So the resident was a leaseholder of a new build property, which he moved into in April 2022. And soon after moving in, he raised concerns with the landlord about the layout and design of the property. He said there was a footpath missing from the front of the property, so he felt there was no way to access his driveway, which was around the corner of the property. There was a grassed area immediately outside, but he felt that when he'd looked at the design plans from the developer, he was under the impression that there would be a footpath there instead of the grassed area. Alongside this, he mentioned there was a manhole cover in the grassed area which posed a trip hazard, and he actually said his child had tripped over and injured themselves on a couple of occasions. And he mentioned the neighbour's car parking space was directly in front of his property, which didn't leave much room for access. And he'd also been unaware of that during the building of the property. So ultimately, the landlord initially said the property had been built in line with specification of the plans, but later in November 2022, it found some previous planning drawings which didn't show the grassed area. And at that point, it was able to liaise with the developer to change the grassed area to a footpath.
Right. This sounds like quite a
Yeah,
complex case.
it's a bit
Yeah.
detailed, yeah.
So sometimes there's a bit of confusion about shared ownership properties and the Housing Ombudsman's jurisdiction.
Mhm.
Hmm. So could you explain the Housing Ombudsman's jurisdiction when it came to this particular case?
Yeah, so we can't consider complaints which don't relate to the actions or the omissions of the landlord, such as complaints about third parties like developers or external surveyors. So we just basically can't investigate complaints that don't relate to the housing management of the
Mhm.
property. And we can't investigate anything that would relate to the conveyancing process or complaints about legal services, which would fall under the legal ombudsman to consider. So, as you can probably tell, a large part of the complaint to us was about the development and the conveyancing process. So, because he was unhappy with the final layout of the property and felt that it didn't align with the initial landscaping and conveyancing plans. But for new build properties, conveyancing checks would usually include checking the correct planning permission had been granted and that the property has been built in accordance with this. So the residents' complaints about those issues, therefore, would be better suited to the legal ombudsman, or he could go and seek some independent legal advice on that. So what we're able to investigate is how the landlord responded to the residents' concerns. So taking into account what was fair and reasonable in the circumstances, and we looked at what the landlord did in response to the complaints within what resources were available to it and in line with the relevant policies and procedures.
Wow, so that's really interesting. So, although you couldn't make a decision surrounding the conveyancing process or the plans, it sounds like you were still able to look into how the landlord dealt with the residents' concerns regarding those plans. Like, so,
Yeah,
yeah. So,
yeah,
in essence, how the landlord communicated with the developer to voice the residents' concerns.
yeah, that's right,
Yeah.
exactly.
Right. So, our insight report on shared ownership outlines various recommendations to landlords, and in particular, when it comes to defects in shared ownership properties, much like in this case, our report highlights the importance of effective communication with developers, and this being essential for the landlord tenant relationship when it comes to new build properties. I'd be really interested to know more about what happened when the resident made their complaint to the landlord and how it responded to those complaints.
The resident raised the complaint in September 2022, and the landlord responded in March 2023. The response said it had facilitated changing the footpath and partially upheld the complaint because there had been delays, which it attributed to the developer, and it offered the resident £200 for the delay in resolving the matter. In May 2023, the landlord agreed to investigate the complaint at stage two. And at stage two, essentially just agreed with the findings of the stage one in that there had been a delay, but it had done all it could basically to end up in the end facilitating the change. The resident remained unhappy mainly because he felt there had been a planning failure, but he also remained unhappy because the landlord hadn't responded to his concerns about the car parking space, which he'd raised in the complaint. And he also was unhappy because the landlord hadn't responded in relation to his child being injured by the manhole cover, which he had reported to the landlord as well. So he complained about the prolonged and delayed complaint handling, essentially. Um, but then once we confirmed the case for investigation, the landlord actually sent further correspondence to the resident identifying the failings in its complaint handling.
So, but what did you find in relation to the residents' complaint about the footpath issues and the manhole cover?
So initially, we did find the same as the landlord that there had been a delay in resolving the matter with the developer, and that it had acted reasonably when the developer had initially declined to change the footpath because it explored other options with the resident, such as making an adaptation request, and said it would support him with that. It also identified there were failings in its communication and updates, which also contributed to the delay. However, we did identify other failings that the landlord hadn't taken sufficient action to address the residents' concerns about the manhole cover. Um, that situation was basically unresolved until the path was put in February 2023. So, he made this report in September 2022. So that's a substantial amount of time living with a trip hazard that he'd informed the landlord had caused injury to his child. We saw that he'd raised it several times in his correspondence with the landlord throughout the complaint process. So we did find maladministration for that. And we ordered £500 instead of the £200 the landlord had initially offered.
Oh, okay. So, you also investigated the landlord's complaint handling in this case. What were your findings in relation to this?
So there was a significant delay in the complaint handling. The landlord responded 127 days outside of its policy timescales for the stage one complaint, and we found there was around a 47-day delay at stage two. And the landlord hadn't responded to the residents' concerns about the car parking space that he raised that his neighbours' cars were parked too closely to his property. While, that was a development and conveyancing matter, the landlord ought to have responded to provide its position because it had responded to the pathway, but not the car parking. And really, it ought to have provided a reason for that.
So, we're talking about this case because the landlord made positive changes in its response and demonstrated learning from the complaint. So, In this case, there were delays in complaint handling, but as you mentioned earlier, following this, the landlord made further contact with the resident in May 2025, where it demonstrated positive changes. Those changes were outside of the internal complaints process, but were before you investigated the complaint. Can you describe how the landlord improved its approach?
Yeah, so by May 2025, when it sent that letter, we'd accepted the complaint for investigation, and then I think when it was gathering evidence for our investigation, the landlord identified that some further failings in its complaint handling and took further action to put it right. This was quite detailed and demonstrated good learning from the complaint. So I'll just go through what the landlord said it had done since making those findings. So it said it had restructured its complaints team by expanding its size and focusing on specialised training in customer service and complaint handling. It hired additional team members to ensure sufficient resources were available to handle complaints efficiently. And it had streamlined its complaint process to ensure all customer concerns were formally recorded, tracked, and acknowledged within the timeframes set by its complaints policy. It introduced new processes to monitor complaint handling, ensuring it adhered to response timelines and early identification of potential delays. It implemented additional training for the complaints team to improve handling and responsiveness. It introduced stricter monitoring and tracking of complaints to ensure timely escalations in line with its policy. It also said it had provided staff training to ensure staff were well versed in complaint handling and the guidelines. It engaged external solicitors to deliver training on the Housing Ombudsman, the Complaint Handling Code, and the statutory requirements in November and December 2024. In addition to all of that, it also offered a further £500 solely for the complaint handling failures. So we did find that considering the impact on the resident was largely linked to the poor handling of the complaint and the delay, the amount of compensation for complaint handling was actually appropriate in line with our remedies guidance for maladministration. However, we were unable to consider it as reasonable redress because the offer was made after we accepted the complaint for investigation. And it basically did not act in line with our dispute resolution principles in identifying the extent of the failures within its complaint process. Therefore, we had to still find maladministration in the complaint handling and ordered it to pay the £500 that it offered.
So you mentioned the determinations briefly there. So what were the determinations on both points in this case?
Yeah, there was maladministration by the landlord in its response to the residents' reports regarding the absence of the footpath, and also there was maladministration by the landlord in the handling of the complaint.
Right. So a lot of the time, we see landlords make these positive changes, but they're usually made after the determination. But this case, as you've mentioned, is a little bit different because the landlord reached out to the resident before you made your determination to make those changes. Can you explain to us how the positive changes made by the landlord impacted your decision when it came to making your determinations? You mentioned it was maladministration, but how did
Yeah.
those changes impact your decision making?
Well, essentially, if the landlord had identified the failings in its complaint handling during the complaint process, then we probably would have found reasonable redress, because it had taken action to put things right for the resident, and it had also shown that it had learnt from the outcome of the complaint. However, if it hadn't have taken those additional steps, we may have found severe maladministration regarding the handling of the complaint, just because of the extensive delays and the fact it missed an opportunity to respond to part of the resident's complaint.
Wow. So this case could have easily been one with an outcome of severe maladministration if the landlord hadn't have made those changes.
Yeah.
Yeah. So I'm wondering whether you've heard from the residents since concluding this case?
I have actually, yeah. He provided some really positive feedback, which was lovely to hear. So he said he'd like to express his sincere thanks to the Housing Ombudsman team for their support in handling his complaint, and that he was especially grateful to me. And he said that I managed the investigation with real professionalism and care, and the final report was detailed, balanced, and clearly reflected a strong understanding of both the facts and the personal impact involved.
Wow.
Which was really lovely to hear. Yeah,
Yeah.
it's funny singing your own praises, but yeah, I just really appreciated that because obviously in this case the findings that I'd made weren't really what the resident was hoping to achieve. However, I did put quite a lot of effort into really getting to grips with the complaint and understanding the processes involved, and made sure that I did provide an in-depth response that was clear and well reasoned, so that the resident understood the outcome and ended up taking it quite well. So I just think it's an example of how we can achieve a fair and reasonable investigation, even in a case where we might not be providing the outcome the resident wanted.
Yeah, that's such amazing feedback. And as you said, especially in a case where not all aspects were within our remit. Um, and it's really clear that the resident was still really happy with your investigation. It seems that the resident not only felt that you investigated the case thoroughly, but also that you took into account how this complaint impacted them personally. And taking a human centric approach is something we talk about within our Spotlight report on attitudes, rights, and respect. And it's clear you adopted that approach here. I feel that landlords would probably benefit a lot from hearing more from you about how you achieved this kind of human centric approach. Could you tell us more about how you did this?
Yeah, so I could empathise with the resident's position. After reading through his correspondence, it was clear that he'd been concerned about the manhole cover issue, and the landlord had done very little to address that. I always give the resident an opportunity to explain why they remain unhappy with the outcome, to ensure that they feel heard and assured that we are considering everything that they're bringing to us. So we were able to pick up on an area where the landlord could have potentially done more in this case, just by doing that, really. For the remaining concerns, I think just setting out at the start of the report our jurisdiction and what we are able to consider helped to manage the residents' expectations there, and just reassured him that we were undertaking a thorough investigation of the areas of the complaint that we were able to consider.
Wow, that's amazing, Charlotte. And I really think that you've demonstrated quite well the importance of managing expectations, but also making sure you do it in like an empathetic way. Um, it's clear that you've really helped to build trust with the resident and achieve a positive outcome here. It's such an amazing case, and I think you've done an amazing job as well here. So that
Oh,
actually
thank
brings
you.
us, no, you've done fantastic,
Thanks
Charlotte.
very much for
Yeah.
having me. Thank you.
So that brings us to the end of the podcast, and thank you so much for sharing such an interesting case with us today, Charlotte. We've covered quite a bit, including our jurisdiction, taking a human-centric approach, and good practice examples that landlords can benefit from. So I'm going to keep saying it, but thank you, Charlotte. Thank you so much. And a big thank you to everyone out there who's listening too. If you're listening and want to find out more about our decisions or some of the reports that we've mentioned in the podcast today, you can find these on our website, including our insight report on shared ownership. And something for the member landlords out there who might be listening. If you are a member landlord and you're eager to learn more, did you know that you can actually get free access to our Centre for Learning Landlord Hub, which has a whole host of learning resources? You can find out more on how to join on our website, www.housing-ombudsman.org.uk. So that's all from me and Charlotte today, and thank you for tuning in. And thanks again, Charlotte.
Thanks so much.
Thank you.